Kenya proudly promulgated a transformative constitution with the sole aspiration of ending the era of the all-powerful imperial presidency and its vestiges, and in its place assert the sovereignty of the people and the supremacy of the Constitution. The Attorney General, retired Judge Honorable Kihara Kariuki, pronounced to the whole world the return of the imperial presidency. The Nairobi branch of the Law Society of Kenya condemns in the strongest terms possible the statement by the Attorney General, and we are vigorously opposed to the attempts by the executive to see a return of the dubious historical relationship between the executive and the judiciary, where the latter was a servant of the former, serving at the pleasure and whims of the executive. It is now safe to say that the courts within Nairobi and Kiambu counties are fast approaching paralysis, and this has been aggravated by the President's refusal to perform his constitutional duties and appoint the 41 judges recommended for appointment by the Judicial Service Commission. Regrettably, the Attorney General, who coincidentally participated in making the recommendations for appointment, has stated in quite clear and unequivocal terms that the executive will not be pressured to appoint the 41 judges on the grounds that certain state organs have provided adverse reports against some of the judges. The Attorney General is categorical that the executive will not obey court orders it does not agree with, and that the whims of the executive supersede the authority of the court and the Constitution. The Nairobi branch is of the firm conviction that the Attorney General has demonstrated the highest dereliction of duty and is no longer a servant of the Constitution and the people of Kenya, but rather a glorified altar boy at the temple of executive impunity.